I don't normally cover press releases because press releases are put out by a company with obviously a slant to their angle. But I thought this was interesting. The bigger context of this is Lexington Law, which is the biggest credit repair company in the nation. It was sued by the CFPB, and the CFPB got what's called a motion for partial summary judgment granted, saying Lexington Law and its related companies have violated certain federal rules and regulations. And they're seeking damages. And it starts with a B, as in like $1 billion or more. And so Lexington Law has put out this press release saying, hey, we filed for Chapter 11 under the bankruptcy code. That would be the equivalent of you or I filing a Chapter 13 bankruptcy. So Chapter 7 is where you try to wipe out your debt. Chapter 13 is where we say, hey, help us reorganize our debt. Maybe there's no interest. We get some time to pay the back stuff we owe. Chapter 11 is somewhat similar to that for corporations. And so what I want to do is just go through and see what they say. Obviously, this is written with an eye to make Lexington Law look good. If the CFPB issued a press release, it would be with an eye towards making Lexington Law look bad. And then we'll kind of talk about the practical effect of this. So the firm continues serving its clients that are hamstrung by low credit scores, which are often a misrepresentation of the risk they present to creditors. And so what they're saying there is actually correct, that if you have negative information that is inaccurate or incomplete, then that should not be on your credit report. The fact that it's on your credit report is lowering your credit score, which then paints a false picture of your credit risk, because your credit score can only be based on, or at least for the big three credit bureaus, Equifax, Experian, TransUnion, is only based on the information that's in your report. And if stuff is in your report that should not be there, then you're getting a false credit score. So we remain steadfast our commitment to consumers. John Heath, directing attorney of Lexington Law. So here's kind of the context. Years-long battle with the CFPB over interpretation of Federal Trade Commission rule covering the timing. They say after vigorous defense, and I will say that they did make good arguments. CFPB made, according to the judge, better arguments, and the CFPB had the law on its side. And if there's interest, I'm happy to go through and analyze that order that came out a couple months ago. And so you can see it, but basically it involves, there's something called the telephone sales rule that says if you're doing credit repair and it in any way involves, we won't get into the details of this, but telephone solicitation or telephone sales, telemarketing, then the credit repair place is not allowed to charge you until 6 months after the account's been deleted. Sort of begs the question, well, what if you're just trying to get the account corrected? But it says deleted. And then you have to pull a credit report to show that it's still deleted, and then you can bill. Now, this is in addition to CROA, Credit Repair Organization Act, which says you cannot charge people before you do the work, which I'll just say most credit repair places do that. They try to disguise it by calling it a setup fee or administration fee. It doesn't really matter what you call it. It's garbage. It violates the law. Okay. So that's just the problem with a lot of the players in this industry. And so here, Lexington Law said, look, this is unworkable. We can't do all this work and then not be paid for 6 months. And we have this federal law, CROA, which doesn't require this. And you guys are trying to impose this, telemarketing sales rule on us. And the court rejected that argument. And so District Court, Utah disagreed and imposed 6-month billing delay for clients following an inbound phone call. I think it's a little broader than that, but anyway. So cease billing practices subject to litigation. I think that I may be wrong on this, but I don't think Lexington Law is taking new clients. I don't know what they're doing with the existing clients. Sudden change in business model, dramatic reduction in revenue. I mean, you have to understand the revenue of Lexington Law and its related companies is just staggering, the hundreds and hundreds and hundreds of millions of dollars a year. So they've had to have extensive layoffs, impacted the employee base. So you can see they're kind of wording this like, hey, you're really hurting our employees. sort of ignoring the fact that at least this judge, whether right or wrong, has said, hey, you guys have ripped off untold, tens of thousands of, consumers across this nation. So abrupt disruption, move towards restructuring, and then they say we filed just sort of routine motions with the court so that they can continue to pay wages and benefits and suppliers and things like that. Now, some of these are going to be, I think, related companies here. And then they say, founded to revolutionize credit repair, providing ethical, effective credit repair, experienced lawyers and paralegals. So, all right, that's the press release. So we'll see what the bankruptcy judge does with it and how long that maybe delays the federal judge in Utah from doing something. So this was filed, I believe, in Delaware. It's where these things normally are filed. So what does this mean for you? Well, it does show you that you really need to be careful if you're paying money to a credit repair place. Because if the credit repair place is not following the law, then it would be reasonable to ask yourself, well, if they're violating the law over here, are they going to violate the law with me? Okay, there's a lot of bad actors at this. Now, there's a lot of good people in the credit repair space that are really trying to do the right thing. But the law is set up so it's very, very difficult to do this and make money at it, okay? So you have to ask yourself, all right, is this place following all the rules? Are they going to be very transparent with me? So I'll give you a couple suggestions. You want to see any letters before they are mailed. Now, a lot of credit repair people will just absolutely have a come apart about that. I can't possibly show these letters to the client. Yeah, I know I've got the client's name and maybe his signature on there, but I can't let them see the letters or they'll just do it themselves. Let me tell you what, there are countless templates out there. We have templates out there, that we use in my law firm that you're welcome to have. Just reach out to me through my website. And so this idea that somehow this is super secret, and trust me, I've looked at, I can't tell you how many credit repair letters from super large credit repair companies to mom and pop place. The letters are not very good. Okay, there's nothing particularly good about those letters. So when they won't give it to you, that's a bad sign, because you need to see it first and approve it, or it may not be considered a valid dispute letter. And you just need to know what's being said. So we have these big credit repair companies that will take identity theft accounts and write what are called sort of good faith letters to the furnisher, Capital One, Chase Bank. Say, hey, I've been a long time customer, really enjoyed working with you. I had some lates. Can you fix it? Well, if that's identity theft, that just guts your ability to sue for identity theft, because you just wrote a letter. I mean, it's got your name on it. The credit repair place did it for you. It says that you've, been a customer of theirs. Well, if it's identity theft, you've not been their customer. So you really need to see the letters before they go out. And if you have any question about what the letters mean, you should ask the credit repair company, like, hey, explain this to me. Let's get on the phone. Let's do a Zoom call, make a Loom video, whatever it is. Explain to me why we're disputing these accounts, what exactly we're disputing, what are we trying to accomplish here. Again, if a company says, we won't do that for you, make your own choice, but why would you stick with that company if they won't explain this to you? Pretty serious stuff, trying to fix credit reports that have errors. And if the company that you're paying money to, maybe that can't even legally charge you money, if they are not willing to explain this, it's just not a good sign. You make your own decision on that. So that's the practical thing I would say, is make sure that you know what the letters are, what the goal is with them. When you get results back from Equifax, Experian, TransUnion, Innovis, whoever it is, then somebody needs to sit down and explain to you, okay, here's what that means. Like, they fixed it, they did not fix it, let's do another dispute, let's sue. Like, what's the plan here? And the plan should not be, well, let's just keep billing you $150, $200 a month or $99 a month or whatever it is. No, let's set up a plan and figure out how we're going to get this fixed, okay? And So that's what I would suggest to you. And if you're interested in knowing more about the orders in this case and the arguments both sides made, they had good lawyers on both sides. Just let me know, and I'm happy to do a video on that. And appreciate you watching this, and I'll catch you later. Bye-bye.